Miss Watson.
So could I begin with Berkeley Curl, which is the authorities tab 10. It starts at page 79. Berkeley Curl essentially in my submission gives us a definition of provision of what that means. And Benedetto tells us what the word on means. But obviously there's some overlap. But Berkeley Curl. And the key to Berkeley Curl and understanding any glosses that appear within the judgments is that a dry dock just is a hole in the ground below the water table. That is what it is. And that comes across very clearly when you look at each of the judgments, and each of the judgments must be read with that in mind in my submission. So beginning with Lord Reed, at page 83 of the PDF. And at B, you see the respondents say the whole dock was part of their plant. So that's the case being put, used by them for the purposes of their trade. And then picking it up at just above E, so there's some discussion above in relation to the meaning of the word plant. And here it is apparent there are two stages in the respondent's operations. First, the ship must be isolated from the water, and then the inspection and necessary repairs must be carried out. If one looks only at the second stage, it would not be difficult to say the dry dock is merely the setting in which it takes place. But I think the first stage is equally important, and it's obvious it requires massive and complicated equipment. No doubt a small vessel could be got out of the water by the use of comparatively simple plant and machinery, but clearly that's impossible with a very large vessel. It seems to me that every part of this dry dock plays an essential part in getting large vessels into a position where work on the outside of the hull can begin, and that it's wrong to regard either the concrete, so this is the concrete lining of the excavated hull, or any other part of the dock as mere setting or part of the premises in which this operation takes place. The whole dock is, I think, the means by which, or plant with which, the operation is performed. Now, because the dry dock actually just is the whole, and we've got the concrete lining is part of the plant, clearly then there's a matter of English language. There are different ways of describing what's going on. But conceptually, the excavation of the hull makes the dry dock. There's no dry dock without the excavation of the hull, and the concrete lining is part of the plant. So what's being done by the excavation of the concrete lining is actually the provision of plant, because you're making it, and without the excavation, as it said later, the plant could not even be made.
I follow it says later that without the excavation, the plant couldn't be made. But they're not saying that the excavation is plant, are
they? No, and the excavation is an activity. So it's the cost of but the excavation is part of building, really, or making or fabricating the dry dock. So it's and maybe it's a bit odd to call digging a hole when the hole itself is part of, creates the dock installation, but in a way those words don't matter. What they're doing is constructing the dry dock. It is part of the fabrication of the dry dock to excavate the hole.
This may just be a linguistic quibble. I'm slightly puzzled by the way you put it, and the way you say a dry dock just is a hole in the ground. I mean, surely the dry dock is not. It's what's constructed inside the hole.
But it has to be beneath the water table.
Well, it does, but it needs all the equipment.
Oh yeah, I mean,
attached to it to enable ships to go in, water to be drained in, drained out, and so forth.
And that's why the hole is plant rather than, say, a dam, just as a storehouse of water. But what I mean is that...
I mean, that's not an odd distinction. Anyway, sorry, we're not dealing with those cases now.
No.
Well, I always conceptualised Berkeley Curl as somehow in this, almost like a sort of tool you might have, like an adjustable wrench or something, just enormously writ large in such a way that you can use it to hold the ship while the work is being done on it and so forth. But it's
that fundamental to it is that the hole is excavated beneath the water table so that the water naturally flows in and out. That's a fundamental part of how the the dry dock operates.
Right. It's just taking advantage. Yes, it has to take advantage of the fact it's on a tidal river, and it has to be
Beneath the water table, I suppose.
well. It has to be a sufficient depth, obviously,
Yes.
so that yes.
Yeah.
But perhaps I'm not sure you can pump water in as well as out. But anyway.
Miss Perry might know better than me about the engineering of a dry dock, but I mean, we're lawyers, not engineers or specialists in dry docks. But as Lord Reid is also a lawyer, then over the page at page 84 of the bundle at B, the question whether the cost of excavation necessary to make room for plant is part of the cost depends on the proper construction. So now it's being put at the cost of excavation necessary to make room for the plant. But all of this is just the difficulties of the English language and lawyers trying to describe what is actually fundamentally the construction of plant, which involves and requires, in order to make it, the excavation of a hole in the ground and then the lining of it with concrete. And so that D. So the question is whether, if the dock is plant, the cost of making room for it is expenditure on the provision of the plant for the purposes of the trade of the dock owner. In my view, this can include more than the cost of the plant itself, because, so this is more of a general observation, because plant cannot be said to have been provided for the purposes of the trade until it's installed. Until then, it's of no use for the purposes of the trade. So here we get the idea of provision being the supply for use. It's a practical concept. It's the making available for use which is the provision. This plant, the dock, could not even be made until the necessary excavating had been done. And my learned friend relies on that. It's not saying anything that's a necessary preliminary to the provision of an item of plant is allowable. That's reading it much too broadly and taking it wholly out of context. What Lord Reid is doing is describing what he's just factually described in the previous paragraphs, which is a dry dock which cannot even be made without excavating beneath the waterline, beneath the water table, because that excavated hole with its concrete lining is part and parcel of the very item of plant. It's unusual because what the court have decided, or does decide, is that premises is plant, which is obviously slightly odd. But that this is the context. So this is not setting up a very wide test of anything preliminary to, or anything that might even be necessary to, is allowable.
And I wasn't paying proper attention. Was that in relation to the words necessary excavating?
Yes, could not even be made until.
I mean, the
necessary.
last sentence looks a bit more general.
Yes, so then he goes on, all the commissioners say is it was too remote. There, I think they misdirected themselves. If the cost of the provision of plant can include more than the cost of the plant itself, which just goes back to the fact that provision means provision for use. It has to be for the purposes of the trade. I do not see how expenditure which must be incurred before the plant can be provided can be too remote. But the context here is he's talking about, and the facts before Lord Reid are, the dry dock. And all he said above is that it can be more because it has to be available for use. The plant isn't provided if it's still sitting at the shop, or if it's in its component pieces and hasn't been assembled. So in my submission, that can't be taken to then suddenly expand the test well beyond anything before the court. In context, it's retaining a narrow meaning, which is the purchase price and all the installation or here excavation costs.
You're right, the problem here is the English language is being used to describe what's happening in order to try and fit it within the statutory test, which is expenditure on the provision of plant. But why do you latch on to the words until then it's of no use as being what the House of Lords here was defining provision as, rather than some other part of the case, for example, letter E about necessarily incurring expenditure? Why is it that phrase which is the decision here?
Well, because that's where he does explain this can include more than the cost of the plant itself, because plant cannot be said to have been provided for the purposes of the trade until it's installed. And then I say that he's not going further below. He's saying the same thing in different words. What is necessary for the provision to be made coate, if you like, or complete? Well, it has to be delivered or installed or transported. My learned friend relies on letters G to H below. So here the word used, so we're looking here at section 300, which is, it's a deeming provision. So it recognises, and what Lord Reid is actually saying here, which is against my learned friend, is that mere installation in a building is allowable under the general rule, what we now have as section 11. There's then a deeming rule which allows capital expenditure on alterations to an existing building incidental to the installation of. Now, this is a provision that was dealt with specifically on the facts in J.D. Wetherspoon, and I'll take the court briefly to that. But here, what's said by Lord Reid is not evidence of some much wider meaning to the meaning of provision or to the test in section 11.4. And actually the key to it is the use by Lord Reid of the words mere installation, which is just between G and H. So he says, here the word uses incidental. Incidental is a wider word than necessary, in my view. Expenditure necessary for the installation of plant is already covered by 279. And my learned friend says, so that means that anything necessary is allowable. But it may be that the exigencies of the trade require that when new machinery is installed in existing buildings, more that shall be done than mere installation. So Lord Reid is actually defining necessary or using necessary and mere installation as meaning the same thing. In order that the new, and then he goes on and explains how section 300 works. And it's picked up and analysed further in J.D. Wetherspoon. So that doesn't support any broad reading of the test, and it doesn't support my learned friend's case. Over the page, I just touched very briefly on it, because in my submission, it's best to stay away from what was then 278 and has now turned into something different. There's a comment that expenditure incurred on the construction of the building might be have quite a wide meaning. In fact, we see Lord Mr. Justice Brightman in Benedetto in the High Court thought it had a narrow meaning. So I don't think there's a clear meaning of the word construction. Anyway, I say that nothing turns on that for our case. So that's Lord Reid. And then Lord Guest at page 89. And at C, Lord Guest sets out the definition, the classic definition of the word plant. And then just above F, he says the emphasis is on an apparatus used for carrying on business. And then he makes the point that it is possible to be both a structure and plant, which is obviously important for Berkeley Curl. And then he says the question, therefore, is whether, notwithstanding that it may also be a structure, the dry dock is plant within the terms of section 279. Conjunction of machinery and plant suggests to me they should both perform some active function. In order to decide whether a particular subject is apparatus, it seems obvious an inquiry has to be made as to what operation. The functional test, therefore, is essential at any rate as a preliminary. The function which the dry dock performs is that of a hydraulic lift, taking ships from the water onto dry land, raising them, and holding them in such position that inspection and repairs conveniently be effected to their bottoms and sides. It's unrealistic, in my view, to consider the concrete work in isolation from the rest of the dry dock. It's the level of the bottom of the basin in conjunction with the river level which enables the function of the dry docking to be performed by the use of dock gates, valves and pumps. To effect this purpose, excavation and concrete work were necessary. So I think that, perhaps I should have put it in that way, but I was trying to just isolate out the point that being beneath the level, the river level, is an integral part of being the dry dock, and the dry dock performing as its function as a dry dock. And the excavation work, the activity of excavating, actually constructing, and the concrete work were necessary because that's how the dry dock as a physical item of plant was made. So necessary there is quite literally describing how the dry dock was made, was physically constructed. So again, that's not setting up a necessary for test. It's actually describing something very narrow, a narrow provision. And then it said the dry dock similar to premises like a factory building. This comparison is not, in my view, accurate. The factory is by itself a building or structure, but the excavation and concrete work is useless for any trade purpose unless used in conjunction with the rest of the equipment. As Lord Justice Pearson, as then was said, the subject is part of the plant with which the business is carried on. So this is the problem of English language, but the whole is part of the plant. The excavated whole is part of the plant. And then, if I could pick it up at F, because Lord Guest, here we again have the word remoteness, although perhaps that's just the commissioners. Sorry. Anyway, it only remains to deal with the second point raised by the appellants. This is that even if the concrete work were plant, the cost of excavation didn't qualify under Chapter 2. The commissioners upheld the contention of the revenue, their view being it was too remote from the provision of the dry dock. In my view, they were wrong in excluding this expenditure. The excavation was a necessary preliminary to the construction of the dry dock. So again, my learned friend says, well, there's a necessary preliminary test which will allow in all the studies in this case. But of course, what's really being described is concreting the lining of the excavation which created the dry dock, the plant itself. So the excavation was a necessary preliminary to the construction. In truth, it was the construction, and therefore was covered by the provision of plant under 279. Provision must cover something more than the actual supply. In this case, it includes the excavation of the hole in which the concrete is laid. And as I say, that's all in the context of the facts before the House of Lords.
I mean, however one looks at it, one is left at least with provision must cover something more than the actual supply.
Yes, and installation, transport, and similar. What makes it available for use or completes the provision. My learned friend made the point that maybe in our skeleton we said it didn't, or the Upper Tribunal, I think, said the revenue had submitted that the excavating the hole completed or made the plant co-ate. Well, maybe that was just a sort of a summary of lots of different submissions. I agree that if you're excavating a hole, it's a bit odd to say that that completes the plant, given that it's the thing you do first. But I mean, nothing can turn on that sort of point. It's just that, again, these are sort of just, it's a necessary preliminary in that you had to excavate the hole to create or make the dry dock. It doesn't really matter whether the Upper Tribunal said that that made it co-ate or not. The fact is it made it. And then at the bottom of page 94, Lord Donovan. So he's looking at what I think had been called a piecemeal approach of dividing everything up. And he said, furthermore, I regard the piecemeal approach as unreal. The dry dock ought, I think, for present purposes, to be regarded as a whole, with a W, with all its appurtenances of operating machinery, power installations, keel blocks, tubular sideshores, and so on. So regarded, is it plant or not? And then he gives the definition of plant. And then underneath F, at the end of the day, I find the functional test to be good as any. In the present case, this dry dock, looked upon as a unit, accommodates ships, separates them from their element, and thus exposes them for repair.
Sorry, where are you?
Oh, sorry, just under F.
Oh, I see, yes.
So the key phrase is this dry dock looked upon as a unit. And he says, thus, the dry dock is, despite its size, in the nature of a tool of the respondent's trade, and therefore, in my view, plant. So it's different to a dam, which is more like a storehouse for water. As regards cost of the necessary excavation, of course it's necessary because it's how you build it. I think this comes within the words expenditure on the provision of machinery or plant. Again, regarding the dry dock as a whole. So that's what puts the use of that word necessary in context.
It's the dry dock as a whole.
It's because it's making the plant that he's going to go on and say it's allowable. The cost of necessary excavation. I think this comes within the words expenditure on the provision of machinery or plant. Again, regarding the dry dock as a whole. Similar expenditure incurred in relation to, and then we've got the expenditure on building or construction, which I think certainly by now, in modern times, the legislation may have diverged. So that's Berkeley Curl, and in my submission, it maintains and gives a narrow construction to the meaning of the word provision.
When you say it gives a narrow construction, it doesn't give a wide construction, you say. It's dealing with a particular case, which is relatively close to the plant, you see what I mean?
Yes.
It's not especially telling you how much further or less far to go.
But I can certainly say this, which is what it doesn't do is set up any kind, the generous broad test that the appellants are arguing for. All of the use, whenever you see the word necessary or necessary preliminaries and so on, when they're read in their full context, they do not set up a wide or broad meaning to the concept of provision. Actually, they're describing something very narrow. And what's interesting in a way is what they're saying is, in order that the appellant in Berkeley Curl can succeed, I don't know whether they were the appellant or not, but in order that the taxpayer in Berkeley Curl can succeed, they have to show that the excavation is actually, in effect, part of the plant.
Did they say that?
No, but that's how the case is run. No, what the hazard rules certainly don't say, oh, well, let's not worry about this, because actually on the provision of is very broad, and anything that's necessary or a necessary preliminary or precursor to the provision of these individual items of plant will satisfy the rule. Simply wouldn't have had to be concerned with whether this was a case where premises was plant. And in my submission, the premises plant cases are interesting here because they do indicate the narrowness of the test. You've got to go really quite far to get what is clearly necessary expenditure, to get relief on it, if it's anything to do with the premises or setting.
Would it be right to say that Berkeley Curl was actually the first authority to really focus on the provision aspect of the
I
definition?
think that's right, and I was going to, it was my first point on McVeigh actually, which is it's noticeable in the bundle, it appears well before, it's the first case,
yes.
And it's not only there's no real analysis in it, it's before Berkeley Curl, without the benefit of any authority. So then I wanted to go to Benedetto, which is tab 16. And My learned friend took you through most of the passages, but I just want to highlight the passages on which I rely. And as I said, Benedetto now hones in more on the meaning of the word on and what is encapsulated or encompassed by on the provision of. And so 173 at H, Lord Wilberforce sets out the appellant's argument in favour of the allowance. And the first argument is that interest and commitment fees are in a real sense part of the cost of the rig, or at least part of the cost to the appellant of the rig. So it ought to be within the statutory purpose. And of course that is not the test. Over the page 174, we've got the contention of the revenue is simpler. They point to the relevant word capital expenditure on the provision of plant or machinery. The only question is whether the amounts in question fall within this phrase. It's not sufficient for the relevant expenditure to attain the status of capital expenditure, a point relevant to the revenue capital distinction, nor for it to be described in popular language as part of the cost. Which is another point about this case, which is why I was concerned to be clear about what the Upper Tribunal meant about design costs and what we were actually talking about in this case. Capital expenditure to qualify must be on the provision of plant, and it doesn't follow that because a trader treats it as part of the cost it is. That's fair enough. Here the interest and commitment fees are expended not in order to provide the plant, but in order to obtain or on the loans. They represented money spent on providing the means to acquire the rig and not the provision of the rig itself. And that argument by the revenue is accepted by the court. And my learned friend took you to page 175. And this is a discussion of the Canadian cases, the Sherritt Gordon mines. So the case itself is described at just under B. And then at E, Lord Wilberforce says, in the end, he found the question was fairly arguable, disposed to think interest drawing construction could be part of the capital cost, and so on, similarly commitment fees. But, so the relevant statutory expression there was capital cost to the taxpayer of property. And this, Mr. Justice Carr considered, could include certainly the price, probably legal costs, and might well include the cost of moving the asset to the place of use, and the cost to him of borrowing the capital required. And then Lord Wilberforce says, my lord, the judgment's impressive, perhaps more for the full statement of the arguments on either side than for the actual decision, but as the learned judge said, was arguable. In considering whether it should be followed, and so in effect preferred to the judgment of Mr. Justice Brightman, I bear in mind it arose under a different statute, and one which not only uses a different expression, but whose policy as regards deduction seems to be more liberal than the UK statute. The expression capital cost to the taxpayer makes it easier to include within deductible expenditure costs which the particular taxpayer incurs, whereas the UK words more objectively focus on expenditure directly related to the plant. Thus, the one draws a line around the taxpayer and the plant, and the other confines the limiting curve to the plant itself. And so just stopping there, I rely on that as supporting the revenues case and the Upper Tribunal's decision. And what it's not doing is, as my learned friend might suggest, setting up a directly related test, for example. It's about, what he's doing there is describing the two types of statutory test. One which asks, what did the particular taxpayer have to or choose to spend on the provision to get there, to get to the provision, if you like. And then the other, which is section 11.4, identify the plant and then see what you spent on its provision. And then, as we see, he goes on to say that what you ask is what is the effect of the expenditure. And there is the reasoning that Lord Wilberforce uses is set out on page 176. And one of the reasons is that he would expect, and of course this case was about money, finance costs, you would expect similar taxpayers buying identical pieces of plant to get the same relief. And of course that assumption builds in the idea that you're only going to get relief for the cost of the plant in a way. But he's saying that if you're focusing on or honing in on the plant and its provision, you'd think that if you bought identical pieces of plant, you'd each get the same relief. Whereas if one chooses to borrow, why would they get more relief?
But no one's suggesting in this case that the work that needed to be done by way of preliminaries wouldn't have had to be done by anybody.
No, but that's not the Lord Wilberforce is using this to reason to a meaning of the word on and the scope of the provision, section 11. And the result of the reasoning on the facts before him is that on, which has to have the same meaning, whatever the facts of the case, takes its narrower construction. And in my submission, he wasn't saying, if what you're spending your money on is money, this is the rule. The word on takes its narrow meaning.
But wasn't his focus rather on the point that it was nothing to do with the taxpayer? It isn't the cost to the taxpayer.
Yes.
And therefore, maybe it doesn't help you quite so much.
I think, well, it's just neutral. I mean, it's neutral for the present case.
Yes.
Because the cost to the taxpayer was the studies, and the studies aren't plant.
And I follow that.
So it's neutral. But what I'm saying is, my submission is it doesn't. I think my learned friend was trying to say that this reasoning works well for finance costs. So it's almost, he was almost saying, and I don't want to put words in his mouth, that when you're dealing with finance costs, it takes this narrow meaning. But don't worry, Benedetto should be confined to its own facts. It's not telling us anything about the meaning of the provision in any other case. And as far as it goes that far, I say that must be wrong.
I mean, the trouble is, we can see Berkeley curl at one end, we can see this at the other end. What we need is guidance as to where within that band the line is to be drawn. And on the face of it, we don't get all that much help from this. It has to be directly related to the plant. That doesn't mean that anything directly related necessarily qualifies, but it isn't excluding anything directly related. There has to be a limiting curve. It has to be tied to the plant, not the taxpayer. But none of this of itself really answers our question.
But and also over at E, when he says the words expenditure do not appear, so that's that wider cost to the taxpayer. They focus attention on the plant and the expenditure on the plant, not limiting it necessarily to the bare purchase price, but including such items as transport and installation, in any event not extending to expenditure more remote in purpose. So I think the focus on the plant, the limiting curve, is trying within the limits of the English language to say, start with your plant, and then what did you pay to get it? In a very simplistic way. And it's the purchase price, but it's not limited to that. And then, because that doesn't necessarily make it available for use, so then you add on items such as transport and installation and similar, but in any event not extending to expenditure more remote in purpose.
So what do we get from more, not extending to expenditure more remote?
Well, by analogy, in my submission, I'd say with transport and installation, or the bare purchase price, which is really what the Upper Tribunal decided. So you get the price of the actual supply. It's really easy with the turbines because there was a purchase price and they're off the shelf. Siemens made 4 types and they had to choose which one of 4 they wanted. But the same is true of a bespoke or made to order or partially bespoke item. It's the price of the supply to you of it.
Do we get any help from the fact that Lord Wilberforce does say use and implicitly endorse the concept of remoteness in purpose. I mean, remote is one's more used to it perhaps as a technical expression in the law of contract or law of damages and here, but he's obviously looking at a degree of separation of purpose from the mere acquisition. And purpose is a word of an objective flavour to it, especially when one's read what goes before it about the subjective circumstances of these particular taxpayers. So, I mean, this is perhaps clutching at straws a little, but the kind of clue I get from this is that one is certainly entitled to look under the heading of provision at expenditure going beyond the actual acquisition cost. What one should do is objectively, and with a concept of remoteness as a limiting consideration.
Yes.
Doesn't take on all that far, perhaps, but at least that's a start.
And I would gratefully adopt that the reference to the more remote in purpose again feeds back to really the bare purchase price and these parasitical items being, it's not really just the paradigm, but the paradigm in the sense of this is the easy way of saying what it means because the facts are relatively simple. But when it gets more complicated, because the world is more complicated, you still come back to saying, by analogy, is it the same as that?
One gets tangled up in language naturally. Here, the money was, the cost was incurred on finance, not on the plant. Expressing it that particular way. If you have to carry out certain surveys in order to finalise your design of a foundation, now I think you would say, well, you're not spending the money on the foundation as you ultimately order it, because you're spending the money on determining what sort of foundation you order. But you are spending the money on procuring a foundation for your wind farm. So it rather depends on how you express what you're concerned with the provision of. Are you concerned with the provision of this particular foundation as you've ultimately determined that you have to order it? Or are you concerned with the provision of a foundation to go in your wind turbine in this spot?
But that approach runs the risk of the abortive expenditure. And I mean, and everyone's agreed in the sense that you start with the actual item. So then you're asking, on that item, as a matter of fact, did you incur the expenditure on its provision? And actually here, if you go and have to do a geophysical study, gathering all sorts of data, which can advise you and your decision making to facilitate a decision about what final instructions to give. I mean, actually, you can identify an on, and it's on the data and the advice and possibly intellectual property, but it doesn't really matter whether it is or it isn't. What your and then it does have a separate existence to the plant itself. It is not itself plant. It enables or facilitates, much like finance, the provision that you...
And that's sort of what I'm getting at. If that is our issue, does this necessarily help? Because it's dealing with how far considerations particular to the taxpayer matter, whereas we're more worried about how far we have to focus on the particular thing you ultimately order, as opposed to the kind of thing that you know you want.
Well, I think that might be true. So this case raises an issue which hasn't been sort of particularly explored yet because of the nature of the facts. But in my submission, one thing neither Barclaycole or Bernard-Decker do is broaden the test in the way that my learned friend suggests. So it's important to remember in my submission that the appellants want pretty much everything, even studies which help them decide whether it's even feasible, if you like, to operate the wind farm at all, and if so, broadly where, or whether to bid for a lease, or so on and so forth. So the appellants are trying to set up a test that will allow them everything. And one important point I want to make is that nothing in these cases supports a test that would do that. Yeah. Nothing in Benedetto does. And then, of course, there's a separate question about, was the Upper Tribunal right to put the line where it did? And, of course, one argument in favour is that, well, yes, it fits the words. It is consistent with everything said in these House of Lords cases. And actually, it just draws a line that can be operated in practice. Because in the end, you go before the tribunal with all of your facts and you say, did we incur this on constructing the dry dock or not? And they decide. And obviously, there'll be, it's easier to do that when you've got all the detailed facts in front of you than to define it as some rule in the abstract, which I think is impossible. So just finishing Benedetto. Over the page at page 177. So Lord Hailsham recognises that the Section 11 could take a narrow or a wide construction. And he comes down decisively on the narrow. And that's what he says at D to F.
Can we just remind ourselves what the two competing versions were?
One would be something more akin to the costs on the provision of, includes the costs incurred either, say, as a necessary preliminary to, or at the costs implying in the words to the taxpayer.
I'm just wondering where he identifies the two different
I'm sorry. I mean, it's probably right back at the start when I indicated the two competing contentions of the revenue and the
Except in the previous paragraph, D to E, he puts forward two rival contentions.
I think it must be referring back to that, isn't it? It is the only question of dispute.
Yeah.
Depends on whether a narrow or broad construction is to be placed on the words.
Yeah.
And Atafi says, in my view, the actual words of the statute are capable of bearing either construction according to the context in which they're used. But at the end of the day, they bear the narrower of the meaning.
So the wide one is all terms properly incurred. I'm not sure the terms quite is what one would say now.
Yes, I see. Sorry. Yes, all terms properly incurred in the provision of the ocean tide, which would include maybe items, maybe terms should be items.
Yes. And the alternative is the only expenditure on the provision of the ocean tide was in effect its price.
Yes.
And as a general proposition, that would be too narrow, but I dare say it was appropriate in this particular case because presumably the price was in effect all that was being argued about on the other side.
Yes.
You see what I mean? Presumably you haven't got transport and installation costs to worry about.
That's right. And maybe they mean by the price of the oil rig. I mean, I imagine this is a huge bespoke piece of apparatus, yes. and many allowances would have been given, but this was the finance cost was an issue. So Lord Hailsham comes down on the narrower meaning. And I just did want to emphasise that doesn't just apply when you're looking at finance costs. It's across the board. It's giving us a proper construction of the statutory phrase, which will apply for all cases. And then down at the bottom of page 177, the appellants also relied on George Guthrie, a decision on the former initial allowance. I don't find the case analogous to the present. And And then equally, Lord Hailsham didn't think Berkeley Carr was relevant.
Just, yes.
Over the page at 178b, he says, it decided that the excavation of the necessary basin for the construction of a dry dock was physically part of the same operation and ranked for allowance as part of the provision on the dry dock itself. So you can see even there, he's describing the physical construction of the thing. Neither really touches on the question of the provision, or on, I suppose, are wide enough to include money spent on the acquisition of money, the main purpose of which was to pay for machinery or plant, as distinct from money actually expended to pay for the construction, purchase, transport and installation of the plant itself. But so again, you've got a sort of restatement of a test, if you like, which is you're fine if you're paying for the construction, purchase, transport and installation. Question is, does it go wider? And actually what the House of Lords here is saying is, no, certainly not. It's a narrow construction.
It's not one of those cases where one can actually find a clear majority in favour of any line of reasoning, is it? I mean, Lord Scarman agrees with Lord Wilberforce, and for the reasons he gives, so that makes two. But Lord Hailsham, for whatever reason, doesn't say anything about Lord Wilberforce's speech, I think, saying whether he agrees with it or not. Lord Salmon was dissenting, and then that just leaves Lord Russell of Culloden, who again, I think, unless I missed something, doesn't expressly tie himself to the views of any of the other four.
But I think what does consistently come out from all is that, or all in favour, is the narrow construction. And Lord Hailsham says expressly at F, I come down decisively in favour of the narrower meaning.
But I have a slight problem with that, because I think I'm not sure I can identify a meaning he's ascribing to the words of the section. Yeah. It's a narrow result as opposed to a wider result. It either includes finance costs or it doesn't.
Well, I think how I would put it in support of the Upper Tribunal is that, and Revenue's case is that if you give provision its ordinary meaning of supply for use of an item, that's the narrow meaning. Then, given, I guess, the language, you can say, well, perhaps you could imply in that on the provision means in connection with or with a view to. I think that's implicitly what the taxpayer must have been arguing, because it was a step before the provision that they wanted relief from. And so that would be giving on a wide meaning, like with a view to. Or...
Can I be unfair? Yeah. Lord Hailsham then goes through a number of factors which presumably account for his coming down decisively as he does. I'm not sure any of those factors necessarily helps us. First, he thinks it's more accurate to talk about the £5 million spent as opposed to the £500,000 on the loan charges. Well, that isn't really our dilemma. Then he says he favours a meaning of the statute which will provide the same allowance for one taxpayer as another. Well, that's not our dilemma. Then he says he's not satisfied about the policy because the policy is to encourage investment. Well, arguably, the taxpayer's construction here does encourage investment, and so on. So, do the reasons he gives really apply in our situation?
But the question then is whether, in the end, that the House of Lords deny the allowances because they have given the phrase on the provision of a narrow construction. They have not construed it to mean with a view to or in connection with. That's what it boils down to. So, and they've obviously got facts in front of them that made it easier rather than a different case to come to that view. But they did come to that view. And it can't mean something different when the facts change. So then the question is, what are the facts of this case? And how does it apply to this case? but giving those words the same meaning. And here, the Upper Tribunal found that fundamentally what the expense was on the provision of vast amount of complex data and advice and data and advice, which enabled a whole host of decisions. Some of those decisions were about whether to commission more studies, and if so, in respect of what, and what area. And there is Ms. Parry will just touch on this because I think it would be useful, but the nature, you can say in this case that the expenditure was on something other than the provision of the plant. But that's then applying the test laid out, or that we can infer from the Benedetto to the facts of this case. And
just to be clear, I think Mr. Jones dealt with this. If you got to the point where you found an expense was incurred both on the provision of plant and on something else, that would be allowable.
I think the answer to that is if the fact-finding tribunal looked at a study and says, actually, this is on whether to carry on the trade at all, even if at some point you can glean some data from it that helps you make a decision about something else that, given the test, it can be said to be on the provision of. I think you'd say that's just not on the right thing. And I suppose it might be vice versa. But if, and then if it's on two things, so you can identify two things are bought under the contract. So that, then we might have a contract which says there's 100,000 for providing the studies or going out and commissioning lots of experts to produce studies. And then there's 100,000 for making some, the turbines if we tell you to go ahead or something, then you would apportion. Or if you can find that it is on two things, then you can apportion. But if it's just on, if this is making sense, it might just be that although it might be seen to be to do with a number of things, actually it's just on one thing, in which case it would be either all allowed or not. But there isn't a wholly and exclusively rule, I think.
Yeah.
Maybe if that's what you're... So the mere fact that something else might be incorporated within it wouldn't disallow the expenditure, but it still has to meet the test of being on.
So just being specific, suppose Mr. Jones were right that, contrary to the submissions you're putting forward, expenditure incurred having as a purpose defining the sort of foundation you would need, but the expenditure was also incurred as part of trying to determine whether or not you wanted to proceed with the farm at all, that would qualify.
I think that must be right. Suppose they're just two equal and there's no wholly and exclusively.
Yes.
But obviously on that situation it might be that you'd have to look more carefully at the studies to say, well, actually, this is just on whether to trade at all.
Yeah.
And yes, just finishing Benedetto. Lord Russell at page 183. And at H, so just above H, he concludes that the finance costs were on the provision of finance, not on the provision of plant. And this is where we get the idea of put yourself in a position. So there are many ways in which a company may put itself in a position financially to provide itself with plant. It can borrow from banks and so on. And then it may, in the net result, be in a financial position to incur capital expenditure on the provision of plant, to provide itself with plant. but expenditure incidental to attaining that financial position is not, in my opinion, within the language. The section, had it been otherwise, quite different language would surely have been selected in order to embrace expenditure so commonly involved as a preliminary to the provision of plant of magnitude. So that's recognising that actually you probably would incur finance costs, and Parliament would absolutely have known that. And if it had thought that you would get, then it would have used different words. So Lord Russell, in my submission here, is also giving that narrow construction. And you do get this idea of to be put in a position to. And that's perhaps, I think, another way in which the concept of remoteness is helpful. Because if it's on the finance costs, or if it's on studies and data that enable the decision making that will facilitate an actual provision, you put yourself in the position to. It's remote from, it's one step too removed from. And because it's on the wrong thing. It's all part and parcel of the statutory test, obviously. And then over the page at 184, this is just a point which the Upper Tribunal accepted and applied in the present case. At B to C, the point was made for the appellant that if the provider of the plant borrowed for working capital and incurred as a result liability for interest or perhaps a commitment fee, these liabilities would be reflected in the price paid. So if Siemens will, in its cost of the turbine, whether bespoke or off the shelf, include all sorts of things will be factored in. No one knows apart from Siemens. It doesn't tell you anything about whether, if the taxpayer incurs them himself, they're allowable. And that's a point of principle, and the Upper Tribunal applied it and accepted it, and in my view, that's correct. And then the obvious point, it said the purpose of these provisions is to encourage investment in new plant and machinery. And of course, it might be said, you might just think, goodness me, why isn't the government encouraging investment in offshore wind farms? We're all, as individuals, entitled to have our own view, but at the end of the day, we're just here to this court is here to just determine the rules. As it happens, I'm told that a consultation has been opened in relation to sort of what the revenue called pre-development expenditure, but obviously it's all irrelevant to what we decide today. And then at the bottom of page 184, this is important. In my view, the question to be asked is, what is the effect of particular capital expenditure? Is it the provision of finance to the taxpayer or the provision of plant to the taxpayer? And here, the effect is the provision of finance. I should add, I don't seek to confine qualifying capital expenditure to the price paid to the supply of the plant. I mean, every single person comes back to the idea that that's the paradigm example of the cost of provision. I should have thought that, for example, if the cost of transport from the supplier to the place of use is directly borne, it would be expenditure on the provision for the purposes of the taxpayer's trade. And there may well be other examples additional to the price paid, which would qualify on similar grounds. So again, you've got this consistently maintaining this close and narrow approach to the legislation. And then what I'd like to do is just take the court, hopefully quite briefly, to the 3 more recent Court of Appeal decisions, just insofar as they touch on the test. And in my submission, what they all do is confirm they're either neutral or they confirm the narrow test or narrow construction. And what they don't do is support the appellant's very wide construction. So the first is Cheshire, which is tab 25. And at 465, sorry, 467, sorry. So this is just the beginning of the analysis. So this was about cavities for the storage of gas, and whether these cavities, there was trying to bring it within the dry dock Berkeley Curl line of authorities and say that they were plant. And so what you get at 36 is the beginnings of a discussion. Actually, it begins further up of Berkeley Curl. And then over the page 37, as I read this, so this is part of Lord Reed's decision or judgments. As I read this, the cost of excavating the dock, if it stood alone, would not have qualified a plant. It was because the excavation was necessary before the plant was installed, it was a qualifying expenditure. So my learned friend says, oh, look, there's a necessary for test. And my submission is no, that has to be read in context. First, the context of the actual facts. Secondly, how Lord Reed was actually dealing with the facts and the test. But also 37 in light of what Lord Justice Lewison goes on and says, and 40 all the way through to 46 are important. And what those paragraphs do is make very clear that Lord Justice Lewison understood the facts in Berkeley Curl and the context in which excavation was necessary before, and it was because the dry dock was a unit. And I think, my Lord Justice Newey, you took my learned friend to these paragraphs, and I rely on all of it, 40 through to 40, the end of 45, 46 actually, the end of 46.
The bit that possibly goes further than one might think was right was 44. The expenditure on excavation qualifies only because it is part of a whole which includes the machinery necessary for the dry dock operation.
I think that that's explained by 45, where he says, this reasoning is, in my judgment, consistent with Lord Hailsham's explanation of the essential nature of a plant. The operating machinery and so on were all implanted onto the land, and the excavation and concreting were both necessary in order to enable the plant to function. Once completed, the dry dock was to be treated as an integral whole. So it was being made, it was an integral whole. I emphasise that's not the way the taxpayers put their case in this appeal. And then equally at 46 little g.
I think in 44, Lord Justice Lewison is really paraphrasing and repeating what Lord Donovan has said in the passage he's just quoted.
Oh.
Yes.
Because there we have Lord Donovan saying, I think this comes within the words expenditure and so on, regarding the dry dock as a whole.
Yes, thank you very much.
But the dry dock is a whole. And the dry dock is put in a hole.
The transcript writer will have trouble.
But the excavation hasn't been said to be part of a hole with a W.
But I think, I think breaking it down, the excavation is an activity, and it's the construction of. It's how you construct or make our dry dock. And I think that's it. And it's not that they built a building or a structure and then said that was plant, where it would be easier. They actually dug a hole in the ground.
But they must have had drawings, and no doubt actually incurred quite a lot of expensive advice from professionals on the feasibility of excavating a hole that size just beside the River Clyde in a way which would, when filled with concrete, be watertight and enable the dry dock machinery to be placed within it. So in fact, there must have been a huge amount of preparatory work.
but also where to put it precisely,
Well,
and
who knows?
legal
All
consent.
these issues.
So,
I mean, just issues very similar to those which were investigated in probably much greater detail in the modern world in the present case. But in a way, the mere fact we're not told about all that preliminary expenditure, which must have been incurred, well, perhaps it doesn't really help, because it wouldn't have crossed anyone's mind, probably, that the capital allowance could extend to anything so remote, both in time and everything else.
I mean,
again, it gets a bit circular at this point. By calling it too remote, one's just stating a conclusion. So.
I mean, going back to Berkeley Curl, you just don't know. I mean, as you say, there must have been engineers who told you how to construct this dry dock, and we have no idea whether that expenditure was allowed or not, do we?
Well, I think they talk about the excavation costs. That's what's an issue.
But we don't know what
we
wasn't
don't, we don't know what that means. But
in the case stated, might have fine. Well, you did. Yes.
I think it's not helpful. I think.
No, I think that's probably right. I mean,
but it was referred to at some point below, but it doesn't. But there's no. Well, the focus of the case is about the costs of digging the hole, and it reads as if they're looking at the construction or the excavation costs.
And they obviously were, but we don't know what they weren't looking at.
No.
If you see what I mean.
You don't just call in the bulldozers and say, begin digging here and see what it looks like in a week's time, do you? I'm sure you have to have probably pretty detailed plans drawn up by architects, maybe marine architects as well. But anyway, this is all speculation. But in the real world, I mean, that amount of money, £300,000, was an awful lot of money in those days. You wouldn't embark on that kind of expenditure without having a pretty clear idea of what you were going to do.
But and some of that expenditure might well, on any view, have just fallen in within the idea of excavation and construction costs, and some not, and it could have been arguable, and we don't know.
Because I mean, as you say, this is all a bit pointless. But there must have been engineers or architects who worked out how you construct a dry dock like this.
Yeah. But there's no. Yes, I mean, but we don't.
We don't know what happened about that expenditure. No.
But yeah, well, I mean, the only point I do make is that if it had been a very broad test, they wouldn't have been so concerned about whether it was on the premises or not, whether the premises was part of the plant. So that does suggest that it is narrow. And actually, every comment about when they're either describing what they're assuming to be the paradigm case, it's always the purchase price. And would they be saying that if there'd been 100,000 of design costs, whatever that means, or architects' fees or whatever? So Cheshire in my submission is consistent with the reading my submissions on the reading of Berkeley Curl. It doesn't support any wider test that might support the appellant's case. In Marsat, just because it's behind that tab, so this case concerned the launch costs of satellites, and because of various deeming provisions, it was relevant to discuss whether the capital expenditure on launch costs was allowable when it didn't lead to them belonging to the person incurring the expenditure. And we don't really need to get into that. But there is some help to be got from Inmarsat, as much, if anything, as maintaining the line, if you like. There's no extension in my submission of the test. There's no widening of it. And the issue begins at page 499, paragraph 58. And the only point that I make is, although it's a different statutory rule, it's taken as the same test as 11.4. And so then at 61, the courts say we were taken to Berkeley Curl and Benedetto. And then those cases are set out and discussed with some relevant passages on through 62 and on through to 63. And then at paragraph 63, the court say, in light of these authorities, it's not surprising Mr. Gibbon accepted, whereas the costs of launching the satellites would have constituted capital expenditure on the provision of plant had they been incurred by the, in effect, the person owning them. However, and then the revenue argued, the payments which were made in respect of launch costs lacked the necessary nexus with the belonging ownership requirement. And the revenue were arguing that it had to be on something leading towards ownership in due course. Freestanding expenditure will not do. There must be sufficient connection with acquisition of ownership. And then at 64, the taxpayer's argument is recorded. Mr. Prosser asked rhetorically how, say, transport costs be incurred on the provision of plant, if incurred by an owner but not by someone else. The nature of the expenditure, Mr. Prosser said, is the same in either case. And he says at the end of just by C, one asks, is on the effect or the focus, sorry, he says, is on the effect or function of the expenditure, on what it does in connection with the provision of plant, not the identity of the person paying. And then at paragraph 65 to 66, there is an analysis of the case law and the test. So plainly, expenditure relating to plant will not give rise to capital allowances unless it results in the plant belonging or deemed to belong to the person incurring it. This perhaps answers the question that was raised right at the start yesterday about the relevance of the belonging test, and it was considered, and perhaps it was the issue in Mossad. So it has to belong to somebody. It doesn't have to be the person incurring the expenditure is the upshot, but it does have to belong, because it has to exist, it has to belong to somebody so it can be deemed to the person, belong to the person incurring the expenditure. So section 24 imposes a requirement that in consequence of incurring that expenditure, the machinery or plant belongs or has belonged to him. And then section 61, little 4, deems the plant to belong to the lessee. Expenditure on plant must, moreover, be incurred for the purposes of a trade carried on by the taxpayer for allowances to be available. There is therefore no question of wholly freestanding expenditure qualifying for allowances. Someone who incurs costs without thereby gaining or being deemed to gain ownership will not obtain allowances. And although it's common ground between the parties that you do begin with an actual item of plant, I would say that actually that's the sort of authority for that approach. It makes sense in the context of the legislation. On the other hand, I don't see the need for expenditure to be on the provision of machinery or plant as itself imposing any requirement that expenditure should lead towards ownership. As Lord Wilberforce explained, the UK legislation focuses on the plant and the expenditure on the plant, confining the limited curve to the plant itself. What matters for the purposes of section 24 is thus what role the expenditure played in relation to the relevant plant. To give rise to capital allowances, expenditure must facilitate the provision of machinery or plant, but there's no reason to read provision as limited to acquiring ownership. Neither of the provisions say anything to that effect. And Berkeley Curl affords authority that provision must cover something more than the actual supply, and in particular can cover the costs of installation, without which plant would be of no use for the purpose of the trade. So the attention is directed to whether the provision of machinery was for the purposes of the trade, not as to whether it leads to ownership. And in my submission, it's the judgment of Lord Justice Newey. My submission would be that that wasn't an attempt to extend the meaning of Berkeley Curl or Benedetto in any way. It was a summary in the context or for the purposes of the point 4, which was about the revenues argument on whether it led to ownership. Yes. So neutral or generally supportive of the Upper Tribunal's decision would be my submission. I can then just deal with Urenco. So I'm just doing it slightly in order to make it order. So Urenco is tab 27, page 510. And there are just two reasons to go to Urenco. The first is that my learned friend took you to it in relation to the word installation. I just want to make clear the revenue's position on that. But the other is, this is a case where it was about, one of the issues anyway, was about the costs of constructing buildings necessary, absolutely necessary for health and safety reasons, to support treatments which I think sort of cleansed or clarified nuclear waste, radioactive waste. So I mean, there's no doubt that these buildings were absolutely essential. And so one of the arguments run by the taxpayer, it begins at, well, it was the revenues ground of appeal, but in relation to an argument of the taxpayer. And it begins at paragraph 87, which is page 537. And it was just to do with the meaning of provision of plant. And the facts, I don't want to spend too long on this because the arguments for the taxpayer are so sort of strained, if you like, and the facts are obviously very different. But the argument was about a facility, a vaporization facility, which had sort of concrete slabs and walls, which was required to support the clearly plant and machinery required to perform the treatments. And so they provided necessary support. That was really the point for certain pipe work. And I think the revenue had lost this in the Upper Tribunal, but won in the first tier. And the first tier decided that this structure performed a premises type function, so the allowances weren't allowable. And at 90, and this is really just the point I wanted to make, you can see how the argument for the taxpayer was put. So the Upper Tribunal considered this issue as part of a ground of appeal which contended that the first tier's decision unduly restricted expenditure which qualified as being on the provision of plant and machinery. At 89, the Upper Tribunal recorded Mr. Peacock's argument that expenditure on the delivery and installation of plant, or which is necessary to make the plant usable, qualifies for allowances as being expenditure on the provision of plant. So Mr. Peacock there was trying for the taxpayer to extend the meaning of on the provision of to include anything necessary to make the plant usable. So in effect, he picked up on a little aspect, a bit like in my submission, my learned friend does with installation. You pick up on an aspect of the judge-made law and then gloss it into something bigger. So the Upper Tribunal pointed out there's no statutory definition of the phrase on the provision of in the context of 11, and it referred to all the authorities. And then we have an analysis of Barclay Curl. And then at 95, they set out the decision of the Upper Tribunal. And they reject, you can see it, page 539G, the Upper Tribunal rejected Mr. Peacock's argument that the expenditure, in effect on building a building, qualified as it was to make plant usable. So that wider definition was rejected by the Upper Tribunal. And then the Court of Appeal at 96 carries on. In response to this argument, HMRC submit ultimately there's only one statutory question, which is that set out in 11.4, and that was answered by the first tier. And so then at 97, I agree with HMRC, and this is the judgment of Sir Launcelot Henderson. I agree with HMRC. The point is ultimately a short one, but I would find it paradoxical if the walls and floor slab, which so clearly form part of the setting within which the items of equipment in the vaporisation facility operate, were to qualify a plant merely because steel supports for some of those items are fastened to them. To my mind, the natural conclusion to draw is that this feature of the vaporisation facility reflects its role as specialised setting for the operations carried out, in much the same way as the specialised structure of the electrical substation in Bradley. And we have Bradley in the bundle, but I mean, the relevant passage is actually set out here. As Mr. Justice Blackburn said in that case, the fact that features of the structure were carefully designed to accommodate the equipment within does not convert what's otherwise plainly the premises in which the activity is conducted into the plant or apparatus with which that activity is conducted. The facts of the present case are, in my opinion, very far removed from the examples given in the authorities of parasitical expenditure, which qualifies for allowances because incurred in installing an item of plant or otherwise enabling it to function. For these short reasons, I'd allow HMRC's third ground of appeal. Now, obviously, again, this is not the court creating a new test or rewriting, but in my submission, that's a very apt way of sort of describing the nature of the expenditure that all of the courts sort of add on, if you like, the installation, delivery, transport, or similar. It's parasitical expenditure, which qualifies because without it, the plant wouldn't be usable. And that's really rejecting Mr. Peacock's argument that there's this extra, much bigger test that you can pin on making the plant usable. And one big problem here was that the argument run by the taxpayer cut right across the premises plant line of authority. And that's something that's relevant to the facts of our case, because quite a lot of the studies, especially if you read the FTT describing, say, the metation studies or so on, is what they're actually doing is identifying and discovering and creating data about the premises. Now, this is a very exciting premises. It's the seabed, it's the sea, the wave conditions, and the wind and waves. But in the end, all of that is the setting or premises where the plant is to be located or situated. And actually quite a lot of the work and the studies are to do with, in a sense, identifying the most appropriate setting for the plant. And so there's it's not really a danger, it's actually a consequence of the wide test or the broad test put forward by the appellants, is that you're just cutting right through all of the existing well-established distinctions that we know exist. And the point being that if constructing, as in Bradley, the electrical substation, if constructing the incredibly specialised premises, which is an electrical substation, or in Atwood and Andorf, constructing the 79 incredibly well-designed logistical car wash sites, if that's not allowable, then why would advice about how to do it, or where you might best buy the site, or how you might best organise your plant on the site, why would that be allowable if actually building the specialised premises isn't? So I just say that, again, I think Urenco doesn't create any wider test than you. I mean, it's simply restating the narrow, or assuming the narrow position. And actually, it's just a reminder, both it and Bradley, and all the other premises cases, that you can't have a test that just cuts right across all the other case law. Because what you'd end up with is, my loan friend, their case, they want to start with the plant and then, as I say, just look back and see, as a matter of fact, what was spent, and then have all of that. But because of these other cases, like the plant premises, or maybe it's on goodwill, or maybe it's on something else, intellectual property, suddenly you're chopping out bits of that. So it's not an approach that works. It's just not principled. Either they're cutting right across the case law, or they've ended up with this very weird test and it's very hard to articulate what that test would be. So they were the 3 recent Court of Appeal cases on Section 11, or to do with... Oh, I'm sorry. Urenco, there was the installation point. So this issue begins at page 554, and it's all to do with a piece of statute, which includes the word alteration. But our statute is different. We're only looking at Section 11. And I think, all that SSE says is, and this is at 162 of page 556. I think it's 162. Sorry, it's 165, page 557. SSE took the meaning of install from the Oxford English Dictionary. Well, fine, and we all sort of know what it means. And we agree that, the Revenue agree that it might be helpful to look at the dictionary to see what install means, but it's not really any more interesting than that. The question in our case is it on the provision of? And installing is relevant if it's how you make the provision coate or complete the provision. And everything done in that installation process to do that would be allowable. And in the end, you've got to get all the facts and put it before the fact-finding tribunal or agree it between the parties as to what's covered by that. But lots of things will obviously be covered. And what you can't do, which is what my learned friend wants to do, is take an Oxford English definition, or then take, which might use the word process, it's an activity or a process, and then construe the word process and say, well, process is a wide word, so it must include everything that you did in order to get to the installation. That's just a completely wrong approach to Section 11. Perhaps before just finishing the Berkeley-Curl line, a Benedetto line of authorities, very briefly to go to Mr. Justice Brightman's decision in Benedetto, which the Upper Tribunal do refer to, albeit not to. So that is Authorities tab 15. And so my learned friend took you through the submissions for both parties at page 167. And then he also took you to page 168E, which was Counsel for the Crown submissions, which sounds very much like Counsel for the Crown here submissions today. The excavation of the basin was essential to the creation of the dock. The dock could never have been made without such excavation, which is why it was allowable. And then how the Upper Tribunal rely on this decision is because of what's said at page 169, starting at F. Or maybe it's just above. So he says there's one other provision I should refer to, and he goes through the legislation and then just under E, section 18 reads, and that's our case, section 11. And it says to me, just at F, it seems to me that as a matter of drafting elegance, where one was dealing with the erection of a building or structure, a natural formula would be capital expenditure on the construction of building or structure. Perhaps be a little strange to refer to capital expenditure on the provision of a building. So then he goes through an analysis of saying, well, actually I think provision takes a narrow meaning because he's drawing a sort of analogy with construction. Not much can be taken from all of this, to be fair, but what Lord Brightman, what Mr. Justice Brightman is assuming is that construction here just means the erection of a building. So he's just making a very narrow point, and he's saying, well, I think that if you talk about a construction of a building, you'd mean the erection of it, which of course would just be limited to the actual costs of building it, erecting it. And then from that, he says, well, the equivalent in relation to plant would be provision. And it's the actual supply of it, if you like, the handing it over or the making it. Now, whether there's any merit in that comparison at all remains to be seen. And the Upper Tribunal said it's not determinative. But anyway, there it is. But he's taking it all to be very narrow. And in the end, it's what the House of Lords say that is the case. Anyway, their construction of a building is given a narrow meaning. We saw in the House of Lords, they thought that construction might take a wide meaning. So I think that's why one, in the end, steers clear of comparisons with constructions of buildings. So then what I'd like to do is look at J.D. Weatherspoon and then look at McVeigh and Mumby and Furlong and Samarkand, which are said to be the design cases, which I say are not at all helpful or relevant to this case, but that's what they're relied on. So J.D. Weatherspoon is Authorities, tab 21. And again, this is really confirmatory of the revenues position or neutral. But one thing it does not do in my submission is justify any extension or expansion of the test so as to support the appellant's case. Now, J.D. Weatherspoon is obviously the chain of pubs and all sorts of items of expenditure in issue. One of, as I mentioned earlier, one of the issues was what was Section 300 and is now, I think, Section 61. So the deeming about expenditure, which is, I should use the precise words, but sort of necessary alterations to existing buildings. So if I could start at page 39 to paragraphs 39, which is page 340. So it's section 66.
Sorry, I was
So
340. Did you say?
Page
Yes.
340,
Yep.
para 39. Sorry, yes, 39. Section 66 provides, where a person carrying on a trade incurs capital expenditure on alterations to an existing building, incidental to the installation of machinery or plant for the purpose of the trade, the provisions of this part have effect as if that expenditure on the provision of that machinery or plant and the works form part of the machinery or plant, the works representing that expenditure. And at 40, and again, this is confirmatory, I put it no higher than that, But 40, it was broadly common ground between the parties that all expenditure on the actual installation of plant and machinery qualified for allowances as being expenditure on the provision of plant and machinery. The parties also agreed that Section 24 extended to expenditure to ensure that plant could actually be operated. So, for instance, in the case of a cooker, the installation expenditure qualifying for allowances under Section 24 would result in someone being able to switch the cooker on and get to it so as to open its doors. Accordingly, Section 66 was not the section that gave relief for the basic installation expenditure. And so that's consistent with the case being put today and the Upper Tribunal's decision. Beyond being common ground, this is implicit in... So sorry, I've missed that. Accordingly, Section 66 was not the section that gave relief for the basic installation expenditure. Beyond being common ground, this is implicit in the wording of Section 66. So this is the judgment, which effectively assumes the installation and then addresses expenditure incidental to the installation. So again, actually, evidencing really just the narrowness of the relief, if you like, which is even if the alterations are necessary, if you like, and incidental. Sorry, I put that wrong. Even incidental alterations, which are probably, or you might regard as necessary to the installation, you can't assume that the expenditure on that's going to be allowable. You might need to look to a deeming provision to allow it. So if it's gone beyond basic installation. So then the dispute was about what further expenditure might qualify for relief when plant and machinery was installed in an existing building such that building alterations were made. On this subject, the appellant advanced a broad construction of the section, whilst the respondents, the revenue, contended for much narrower construction. And I'll just pick up at, sort of summarise the two contentions. So at 41, the appellant contended the expenditure on alterations to existing buildings incidental to the installation of plant included any expenditure incidental to the installation directed to making the plant more usable. So actually that picks up at something close to what Mr. Peacock was recorded as arguing in Urenco. Having regard to the point just mentioned, to the effect that allowances would be available under Section 24 to ensure that installed plant was working, a much wider meaning was given, they say, to Section 66, to the notion of making installed plant usable. So then at 43, in stark contrast, the respondents, the revenue, contended the items for which allowances should be claimed under 66 were for alteration works incidental to the pure physical installation of the plant in an existing building, and not alterations geared to facilitating the better use of the installed items. So they were the two submissions. And then there's 44 to 46 sets out common ground. 47 sets out the appellant's contentions in more detail, and I don't need to take you to that. And then at 54, there's the decision on the meaning of Section 66. We are required to apply the taxable purpose fully. Section 66 does not in terms provide a new or separate category of allowable expenditure. It's a deeming which requires expenditure on certain alterations to existing buildings to be treated as expenditure on the provisional plant, even if it would not otherwise. And then there's an analysis about how Section 66 should be construed, which is not directly relevant to the case before us. But at 55, the appellant's case that Section 66 applies to any alterations designed to facilitate the better use of installed plant would often have the exact opposite result. And then there's a reason why the appellant's broader construction is inconsistent with the policy that's been identified in relation to Section 66, which is consistent with what Lord Reid says right back in Berkeley Curl. And the point I just wanted to make is that alterations designed to facilitate the better use of installed plant are too wide, no allowances. You have to meet the much narrower, more precise words of the deeming rule to get that. So it's not the case that one begins by looking at section 11, expecting everything to be allowable, and then asking why some bits might not be. It is a narrowly focused relief. And so J.D. Wetherspoon, it's not itself on the meaning of section 11, but impliedly it is quite important what section 11, what its natural scope is, because section 66 is being defined by reference to it. And I just say that's supportive of the Revenues case and the Upper Tribunal's case, decision. And the final point just on preliminaries is, because my learned friend has an argument about this, it's at page 352, paragraph 92. And nothing in the concept or existence of the idea of preliminaries helps the appellants argue for a more generous test. One point which is said in the skeleton, and my learned friend repeated in his submissions, and I think also below, that a hint of the idea that, well, actually, look at the word preliminaries. So doesn't it show that something done as a preliminary to the provision is allowable? And look here, everyone agrees that they're allowable. What's made clear at 92 is that preliminaries are just, it's really a misnomer. There is no meaning in the word preliminaries. They're overheads, really. Overheads would be a better term. I don't know why they're called preliminaries. But what they are overheads like insurance or scaffolding, which, as overheads, may be applicable for all sorts of things, but difficult to apportion. And the rule is about an apportionment of overheads, which actually are incurred for a number of different things. But the definition of preliminaries is there in paragraph 92. There's no special magic in the word preliminaries. And the Revenue's position is that consistent with what's set out there. And in fact, the manuals then copy out, I think, the paragraph from J.D. Wetherspoon on preliminaries. And it would mean, it may be that within that comes the cost of drafting the contract of purchase or whatever, but certainly scaffolding and insurance, what the matters laid down there. But the key thing, and I won't actually take you to the manuals, but my learned friend, I think, may rely on the manuals, I'm not sure, but the manuals say that, list a whole load of things that may possibly be preliminaries or overheads, and then it says, if they are on the provisional, then you do the apportionment in accordance with the rule for preliminaries. But whether they are is just a question of fact, and it depends on the legal test. So that's J.D. Wetherspoon. So then if I could turn to McVeigh. And McVeigh is in Authorities, tab 9.
Just before you do that,
Yeah.
You talk about the manuals, and you talk about them specifically in the context of preliminaries. Are you going to come back to them at some point in relation to design costs, so to speak, or that sort of matter?
Yes, I can do just at the end. I'll just do all the 2 manual extracts.
Yes.
I'll just do a second. The first, so McVeigh is tab 9. It starts at page 65. And the first tier and the Upper Tribunal found this case of limited significance or assistance. And that's the first tier at paragraph 128 and the Upper Tribunal at 171. And they were right to take that view. the first point, just chronologically, is it's decided before Berkeley Curl. So it's done without the benefit of any of that learning. And Mr. Justice Cross clearly thought that, well, he was deciding the case on a false premise. So these books of reference containing the designs were tools of the trade. They were tools of the trade used by the styling committee to make choices and decisions about what wallpaper they should mass produce, I suppose, that season. And so, and when a particular design was chosen, then that was, by whatever mechanical means, that was then, I suppose, sort of copied or imprinted onto the relevant block or screen or silk screen to produce the wallpaper for sale. And the wallpaper was the stock. And the printing presses or the printing machines and the blocks were all plant. And actually the individual blocks were probably parts of the plant. So they were made co-ate. It was a common ground that the individual blocks were incomplete until they'd had a pattern cut into them or by whatever mechanical means necessary imprinted into them. And so together the patterned block and the printing press would be the plant. But in order to decide which pattern that they were going to put on their wallpaper in order to sell for their stock, the styling committee had a whole series of designs and patterns which had been produced for them. And Mr. Justice Cross says, you know, left to me, I can't see why these aren't plant. And that's the first issue that he decides. So the judgment starts at page 76. And they're plant because they're like the books of textbooks of a lawyer, when you the law reports, plant. And the fact, and what Mr. Justice Cross understood is the fact that they're used intellectually by the styling committee to make choices and decisions, or to enable them to pick one design over another, didn't mean they weren't the tools of the trade. I guess it was kind of old-fashioned view that only tradesmen could have plant, and professionals and lawyers didn't have plant. Or maybe they could have typewriters, but certainly their books weren't plant.
I see it was Sir James Munby, as he later became, who had the test case.
Yes, and I'll take you briefly to that. So, Mr. Justice Cross says, if had I been free just to decide it, then I would have. I think he's saying I would have held that the books of reference were plant. So this is, first of all, a case which, but he says, well, I feel I can't do that because for 50 years the law's been that unless the tool of the trade is used physically, it can't be plant. That's relevant to how he decides, or what he says about the second point. But just on this first point, the fact is not plant, which is a sort of legal concept, doesn't mean they weren't always the tools of the trade. And so factually, this is a case about reference books which were used as tools of the trade. That's just what they were. The fact that one didn't feel able to call it plant, so you didn't get allowances, doesn't change how they were used and what they were. And so then when he says, well, okay, I can't find that it's plant, or I won't find it's plant, is it nonetheless on the provision of plant? And in the course of, the Upper Tribunal used the word scant, there is basically no, we don't know why he decided what he decided, other than that he felt that something should be allowed. And he does two things. First of all, sorry, it's very difficult to page 77, he says he deals with the first question. That's under the dotted line. And then page 78, can you see if I thought I was free to do so? So that's when he talks about barristers' books. And he says, similarly, the designs, which are the tools of the trade of the styling committee, and many of which are scrapped after a few years, might, I should have thought, qualify as plant, just as fully as the hand blocks, silk screens and rollers, many of which are periodically scrapped. But having regard to Daphne and Shaw, I don't think I can make that decision. So that's what he says about that. And then the second question is, can the cost of acquiring the designs be said to be expenditure on the provision of the blocks, screens and rollers, on which some of them are patterned? And then he gives an example, and he says, well, what if, instead of having the reference books, you commissioned a sort of an experimental block? So then that's a sort of physical item they can physically use in the trade. And I think he says, well, surely you'd get the expenditure of that. But then, of course, counsel for the revenue, I suppose, or the revenue or the taxpayer. Anyway, one of the company's representative says, oh, yes, but, the facts are different. But you can see that even at this stage, he's still harking back to the idea, it's really plant. I'm trying to find a way that these books are used physically. And then he says, well, I accept that they're different. I feel the force of this argument, he says. But the section itself isolates the provision of the pattern wood block and poses the question, what did the company spend on it? And then to my mind, it can't be right to include nothing. And then he just says, well, you can have a fraction of the cost. The right answer must be some fraction of the cost, but he doesn't say why. And you'd think that if he was giving section 11.4 a wide meaning, he must have allowed all of it. But he actually thinks the right answer is a fraction.
Is that right? You've got a whole collection of designs, and you use a number of them in relation to the blocks or rollers. Would you not then say you have a fraction of the cost of the designs?
But I think, and actually this comes out of the statement of case, but also the Court of Appeal in Mumby, the designs that were actually used were allowable as revenue expenditure. So this case was all about the designs that weren't used.
Oh, is that right?
Because this is an ongoing trade. So it's very different to this case, which is a startup. So it's the ongoing trade. And I think, it's not entirely clear whether he's including in his analysis the whole of the designs, including those used, or not. But
I hadn't picked up the fact that any of the cost of the designs was being allowed as a revenue expense.
But that comes out more clearly. I'm not quite sure, but Lord Denning in Mumby and Furlong describes that as being the case. Now, he may have actually just been performing his own analysis. But
So Mr. Nelson's Cross says, I can well understand it being argued that as so many of the designs are never actually put on any block, screen or roller, only some fraction of the total design cost should be allowed. That makes it look as though he's focusing on the ones that are used.
But the indication is that the case is only about the ones that aren't used. And
that's not just from Lord Denning, it's from Mr.
And that
Cross.
the statement of, well, that is the issue in the case. But insofar as he's saying, well, the designs that actually are used, you should get an allowance for that. What all then is happening there is you're making your inchoate plant coate. So and that's very different from this case where the designs are of a very different nature. So either, which I think is how the Upper Tribunal did see it, that the ones you do use make the plant coate, and that I think that was agreed. It was agreed that they weren't complete without the patterns as a plant. So putting the design on the plant, so buying the design in order to do something physical to it to put it on the plant was allowable.
I'm now going to doubtless distort what I think Mr. Jones might say, but I think Mr. Jones might say, well, look, these designs are being used to shape the block. Somebody then carves out on the block, but that's by reference to a design. And that's not really different from deciding how a foundation is put together. You take a design and then you make something consistent with the design. Here you make a design and you carve out the block according to the design.
But the actual cost of gouging into whatever the block was allowed as a revenue expenditure. And then what's not clear is whether the cost of the design was also included as part of that revenue cost, or what Mr. Justice Cross is actually talking about. But on any view, they're different in nature, because the case is about the books of reference of designs that weren't used, but that insofar as the design was used, that is, I mean, it's either actually just intellectual property, and now there'd be intangibles property relief if it meets the conditions, if that's the reason why they weren't allowed, or it's the product, part of the product that you're selling in your stock. I mean, the context is just different. You're buying a design to mass produce it, to sell it.
I mean, I do see what you mean, but at the same time, you're using the design to decide how to make your block.
Yes.
In our case, doubtless you use designs to decide how to make foundations. You don't sell on the foundations. You don't use the foundations to make something else. But you've, in each case, used a design to decide what to make.
But the designs are completely different, because there really is a design in the Sanderson's case. And the truth is, they are tools of the trade. As a matter of fact, they're being used, they are apparatus used intellectually as tools of the trade with which to make profit. And how you use them is the ones actually used is to copy them or imprint them, or one way or another, transform them into the plant. You are using it as intellectually as apparatus in your trade. And the studies are not used intellectually as apparatus in the trade. What you're actually doing, if you strip all of the words away, is you're just buying a lot of information and advice and data in order to decide what do you want to buy, what kind of plant you want for your trade, so you can make or optimize your profit and have a successful business. And that's just completely different in character. And combined with the fact that it really is very hard to work out what Mr. Justice Cross, the basis of his reasoning in this second ground. And he's struggling because he would have decided that the reference books are all plant.
I mean, one thing you can say, of course, is there's no question of this being binding.
No, and it's really very hard to, in truth, work out what the reasoning is as to why he says some fractional cost should be allowed. Other than he ought to be allowed to find their plant and he feels he can't. And that's just what comes out clearly in the Mumby and Furlong at page 146.
Just before you go there, if you do want to follow up what was said in the case stated about the treatment in the accounts, you might want to look at paragraphs 21 and 22 on pages 71 and 72 of the bundle.
71.
I mean, probably not something to take up time on now. It does look, well, indeed it was a finding in 21, in the company's accounts, the cost of rollers and designs is mainly written off annually as a specific deduction in the computation of trading profits. So it was obviously seems to have been allowed as a revenue expense, and the point wasn't taken as capital expenditure. And then in 22, there seems to have been a change of practice after 1928 as to making allowances, again, as revenue expenses.
But maybe that Lord Denning went a bit far.
Wouldn't have been the first.
But I think that it's clear. But anyway, the Mumby and Furlong is at tab 14, and at page 153, there is a discussion of McVeigh, and so the point here is it. So you can see Daphne and Shaw is considered right up at little b, mentioned there, and the issue is whether plant has to be a physical thing used physically, or whether it can be a physical thing used intellectually. And then the one case which deals with items used intellectually is McVeigh. The question was about certain designs which were used for making wallpaper. Some of these were designs used physically on rollers and qualified as revenue expenditure. So maybe that's too general, or maybe submissions were made to him and it makes...
Well, it makes a broad summary. I mean,
yes.
You mightn't need to go into the small details.
But those which were not used on the rollers but only kept for reference as an intellectual exercise. Mr. Justice Cross expressed a good deal of doubt about Mr. Justice Rowlatt's decision, if I thought I was free to do so, and so on, over the page. To B, that was his view, it seems good sense to me. Mr. Justice Cross thought he could not apply it in the case before him concerning the designs. The designs used intellectually didn't qualify as plant, and he didn't want to go back on Daphne and Shaw. And then, so under C, so there it is. Those two judges did not like Daphne and Shaw at all. And then, so the new position down at G, Mr. Med in his excellent argument before us would confine a professional man's plant to things used physically, like a dentist's chair or an architect's table. And I suppose a typewriter in a barrister's chambers. For myself, I don't think plant should be confined to things used physically. On principle, it extends to the intellectual storehouse, which a barrister or solicitor or other professional man has. And so that, of course, would mean that Mr. Justice Cross' instinct was right. And that's what the case is about, apparatus used in the trade by the styling committee. And there's just the final point on McVeigh, I suppose, which is the Revenue put their case very high. They say you don't get 1 penny. And he said, well, that's not right, so I'll decide the appeal against you. But the more important point is it's really very difficult to know on what basis he said a fractional share should be allowed. And then Samarkand, there are two Samarkand decisions. The first is the first tier, which is tab 20. In my submission, this, and it's not the, this is a decision of the first tier, but it is, of course, one of those decisions where there are many points in relation to a highly artificial and difficult scheme. And in the course of that, and actually it is the case on film schemes and whether certain leasebacks amounts to trading, and it kind of is the beginning of the modern law on that, and that's the important point. And so to derive much from, when you get these sort of small technical points with about sort of some little bit of expenditure, there's a limit to how much weight can really be taken from it. And I think my learned friend took you through the structure of the decision in relation to this, so I don't need to do that again. But what we saw was, just for your note really, at page 305, which is paragraph 357, the first tier assume that the artificial scheme does amount to a trade. So then on that basis, they look at the argument about a toya. At paragraphs 383 to 384, they find the fees in question were capital in nature, and you were taken to those paragraphs. And then 393 to 396, there's the first is discussion and findings. So perhaps we should go to that, which is page 310. And although there may be some overlap in how the revenue would treat certain expenditure here in the findings, that the big point I suppose I make is that it is actually considering a different statutory provision which has its own statutory context. It's section 130 to 134 of ATOIA. It's a deeming provision which treats certain capital expenditure to be revenue when it is on the acquisition, and that's the word, of a particular thing, a master negative or rights over film. So in the end, it doesn't follow that because something is allowed by the first tier under that rule, that it must therefore be allowable. Apart from anything else, a master negative is not that similar to studies and data and metocean and geophysical technical data reports. And what the tribunal does at 391 is, in seeking to understand the meaning of the phrase on the acquisition of the asset, or the master negative, they do begin with Benedetto, they're invited by the parties. And then at 392, the Revenues Council referred to section 38 of the TCGA. And then at 393, we note that 134 is not confined to expenditure on the asset, but applies to expenditure on the acquisition of the asset. The natural meaning of that is to include costs directly related to the acquisition. Well, the word acquisition is in italics there, and they are talking about the concept of acquisition in relation to a master negative, where, I mean, you can see that the contract in that case probably creates the asset that you buy, because you're carving out and creating rights in respect of an asset. So then they go on at 394, if we apply Lord Russell's test. But then this is in relation to the word on. So this is not about the word acquisition. What was the effect of the expenditure? In relation to the cost of negotiating and preparing the agreements, it seems to us the answer is not that the effect was the production of a piece of paper, but was the acquisition of an asset. So they're just saying, in the context of the acquisition of film rights, drafting and preparing the agreements and actually negotiating the contracts to determine what you're going to buy is part of the acquisition of what you create by those contracts. And that seems, on the face of it, fair. It doesn't seem to have been appealed, but maybe there wasn't enough money in it, I don't know. But of course it was all hypothetical, there was no trade, so there was no deduction. So it didn't matter. But one can see the merit in what the FTT do there in relation to the words in the section in front of it.
I think permission to appeal was sought on just about everything.
Really?
But then a lengthy decision was handed down. I think it was Lord Justice Arnold who refused permission, but most, by any means all of the grounds raised.
Yeah. And in the end, this is the case on sale and leasebacks and trading, and it's a very important, judgment. It's not known as a case on on the provision of or on the acquisition of. And then equally, they say on balance, at 396, we find expenditure on identifying the films was on the acquisition. But again, there's no read across here, and I think this is of not really marginal relevance, but no real assistance at all.
But superficially, 396 is against you.
On identifying the films?
Yes.
Well,
and so you definitely say that sums spent on identifying what to buy in our context doesn't count.
Yes, but what's said there is on balance. It's on the acquisition of the films, and it is a different. The focus there is on the acquisition. Now there, the FTT has decided that it's on the acquisition. It sounds like, in fact, it was appealed and permission is not given, and that's the end of it. But
Sorry, of course, it must have gone to the Upper Tribunal first,
Yeah.
so I was
Yeah.
Perhaps
But-
completing 2 stages in a marathon.
But it's very, I mean, this is a sort of clutching at straws point in my submission, because it's different statutory words and it's a different asset. And it's the first to making this decision in the context of a very lengthy decision, which is fundamentally about something else on a hypothetical issue. The other Samarkand decision is the Court of Appeal. This is more in the nature of just confirming it doesn't support anything the appellants pay. And it's at tab 22. And I'm so just to sort of, for clarity, to pick up the issue. So the revenues cross appeal at paragraph 100 relates to called the Queen Quantum issue. And it's page 383. And it was whether the first two is entitled to conclude as they did, that they incurred no more than 1% of the sum of 8.1 million on the film, essentially because it was worthless. So it was a question of how well spent was the money. And at 102, page 384, the court say it's now accepted the rights to the Queen, which Samarkand acquired, were indeed worthless or virtually worthless. And then over the page at F, so maybe I just need to set out the context. At the top of the page, of page 385, little a, there's a record of the various arguments that had been run below. And so we've got that submission was rejected by the Upper Tribunal and the appellants not sought to resurrect it. His second submission to the Upper Tribunal was that even if the rights were worthless, the first two were wrong to hold that Samarkand did not incur the amounts paid in acquiring the film, in the absence of any finding that Samarkand knew it was paying more than the asset was worth when it did so. This argument was accepted by Mr. Justice Newey, but rejected by the Judge Sinfield. In support of this argument, then, Mr. Furness relies on Guthrie and Stanton. And Stanton is just about the fact that in a bona fide transaction, the revenue can't go behind it. But in relation to Guthrie, at E, so the commentary on Guthrie starts at little c, actually. In Guthrie, the taxpayer who traded as a butcher in Glasgow paid £1,144 on the intended acquisition of a motor car. Owing to the fraud, he didn't obtain title, which had already been sold to somebody else. And he claimed allowances. And the claim was upheld by the special commissioners and on appeal by the Court of Session. The Lord President said, when, as in this case, there's been a bona fide expenditure of capital for an approved purpose, I consider the Special Commissioners justified in concluding that their concern was with the fact and object of the expenditure, and not whether it was well spent or ill spent, or whether the intended object was or was not actually realised. And of course, then that Guthrie led to the change in the law. For present purposes, the important part of this reasoning is the reliance by the Lord President on the fact and object of the expenditure, in the absence of any bad faith on the taxpayer's part. The fact the intended object was not actually realised didn't matter under the 1945 Act, but would matter under the modern code governing capital allowances, which includes, in response to the decision in Guthrie, a requirement that the plant or machinery should belong to the taxpayer. And so then my learned friend turns to paragraph 110, which is page 387. And what the court finds is that they draw an analogy between for the purposes of on the acquisition of, they draw guidance from Guthrie, which of course the pre-1945 or post the legislative changes, where it doesn't matter whether anything that you end up but having any ownership or title. And the court say, I also find Guthrie of assistance because it shows that in answering the question what expenditure is incurred on, in answering the question what expenditure is incurred on, in a statutory context designed to provide relief for the expenditure, the focus should be on the facts and the object of the expenditure, rather than on whether the money was well spent. I agree with Mr. Justice Newey, that no distinction can sensibly be drawn between the statutory language of the relevant provisions in Natoya, which refer to a person who's incurred acquisition expenditure, which itself means expenditure incurred on the acquisition of the original master version, and the wording in Section 15 of the Income Tax Act 1945, which refers to a person who incurs capital expenditure on the provision of machinery or plant. And in my submission, that's not authority for looking back at the Samarkand first tier and saying on the acquisition of and on the provision of are the same. And because the first tier decided on the facts of that case that identifying films was on the acquisition of, then it must follow that for our case. In my submission, I'm conscious of the court here for many of the decisions. That's essentially about a passage on the meaning of the word on and the nature of that word, and indeed in the context of earlier capital allowances legislation. What's not being said there is that on the acquisition of the master negative can be read as being identical or of great interest and assistance in construing on the provision of. And that's just the point I'm making.
And is that going to be a convenient moment?
Yes, and so then I can just finish with the manuals just early in the morning, and then Ms. Parry will just address you on the facts.
And I assume we're still on schedule.
Yes, we should.
In which case, 10:30 in the morning.
All rise,